G'day everyone, and welcome to the second video for week 11 of our Legal Ethics and Trust Accounting course. This week, as you know, we're looking at how the ethical duties of a practitioner play out in the specific environment of litigation in a courtroom. As we move through the material this week, you'll keep noticing not too much of this stuff is conceptually new. The rules that we're talking about really are based on the same themes as rules that we met earlier in the course. The real difference is that in this case we're applying them in the courtroom. Now, two of the rules that we met earlier in the course were, first, the overriding duty of responsibility to the court, and second, the duty to give effect to our client's instructions. But these two duties can conflict. They can especially conflict in the courtroom. If lawyers were bound to give effect to their clients' instructions in the courtroom, then the case would be run by someone who was emotionally involved and who probably knew nothing about court. It'd be a disaster, not least for the client. And so the principle is that by the time a matter gets to court, the lawyer already knows what outcome the client wants. At that time, the lawyer must exercise their own independent judgment about the best way to get there. It's kind of like surgery. The client might have to give their consent to having a hip replacement, and they might be involved in decision making about some aspects of the surgery. But once the surgery begins, the doctor makes the calls. The first principle underlying all court matters is obviously the pursuit of justice, but the second, very nearly as important principle, is the efficient use of the court's resources. And out of all those resources, the most important one is time. The fundamental reality of all courts everywhere in our system is that they have too many matters and not enough time in which to hear them all. Sometimes people are required to wait an extraordinary amount of time in order to obtain their chance to appear before the court. As a result, the court's first preference is for matters to settle without any need for the court's involvement at all. But if the court does need to be involved, the court's expectation is that practitioners will narrow the issues so that the only matters argued before the court are those that are genuinely in dispute. Practitioners are expected to conduct matters in a way that is mindful of the proper use of the court's resources. This feeds directly into the need for advocates, whether barristers or solicitors, to demonstrate independence in their handling of matters. It's so very easy to imagine a client who says, I want you to fight them. I want you to fight every step of the way. I want you to fight on every point. I want you to take every objection. I want you to put them to proof of every single fact that they allege. However, if you did this, it really would just waste a bunch of the court's time. Not only that, but by testing the patience of the judge, you wouldn't be doing your client any favours at all. Solicitors Conduct Rule 17 says a solicitor representing a client in a matter that is before the court must not act as the mere mouthpiece of the client or of the instructing solicitor, if any, and must exercise the forensic judgments called for during the case independently, after the appropriate consideration of the client's and the instructing solicitor's instructions where applicable. Barristers Rule 41 is set out in virtually identical terms. A practitioner who simply asks what their client demands that they should ask and says what the client demands that they should say is not exercising any independent judgment at all. The next thing to consider is that court is a dynamic environment. There's an old military saying that no plan of action survives first contact with the enemy. The same most definitely goes for court. You can, indeed you must, spend many hours preparing in minute detail for trial. But the only thing you can be absolutely certain of is that the trial itself won't go as planned. Judges might disallow evidence that you're relying on, or they might indicate clearly from the bench that they don't find it convincing. Witnesses might give different answers to the answers you're expecting. Your witnesses might crumble under cross-examination. Their witnesses might come up with answers you hadn't anticipated. I've even been in trials where the judge has produced out of nowhere a relevant case that neither I nor my opponent had identified, and then the judge asked us for submissions in relation to that case. Often, when the unexpected happens in court, it happens in quick time. You have absolutely no opportunity to consult with your client. Or if you do consult with your client, the momentum of the advocacy may be lost. In these circumstances, it's simply not possible, not practical, for the client to be calling the shots. Again, the only sensible way to get through the process is for the advocate to have independence before the court. The corollary of this is that advocates are immune from being sued for negligence arising from their acts or omissions in court. This principle was established by a House of Lords case called Rondell and Worsley, which was then adopted in Australia in a case called Giannarelli and Wraith. There are a range of justifications for the immunity, but one of them, the one that matters to us here, is that if an advocate was open to a claim of negligence every time a client was unhappy with a court outcome, then the advocate would have no choice but to take every objection and call every witness and ask every question and cite every authority. Without trying to exaggerate, this could easily double the length of trials, and it could certainly double or even triple the length of time taken to prepare for trial. Clients would therefore be required to pay a lot more. Court waiting times would continue to extend, and frankly, nobody would obtain any benefit at all. It's far more in the interests of everyone concerned for advocates to be independent in court. Incidentally, the immunity is not strictly limited to in-court work. The High Court made this clear in a case called De Orta Ekanaki against Victorian Legal Aid, and this makes sense. There'd be no point protecting an advocate from liability for, say, not calling a witness in court if the client could just sue the same advocate for failing to prepare questions for that witness while preparing out of court. So the immunity extends to out-of-court work, provided there is a close enough connection with the advocate's work in court. So, we've now met two of the duties of an advocate in court: the duty of formality in court, which includes a duty not to pretend to be over-familiar with the court, and the duty of forensic independence. In the next video, we're going to continue this theme and look more broadly at the duty to make responsible use of the court's processes. See you in video 3.